you everybody for taking your time out on this Sunday afternoon and joining us for this presentation and this series. Hopefully, if anything, it'll be instructive for you as to what this process entailed, how RENA affects you, your city, the community at large, and the entire state. Hopefully more than that, you'll have a better understanding of what we can do as cities on behalf of our communities to really make HCD and this entire RENA process more effective and actually be a process that works for each community, because that's the ultimate goal. With that, my name is Pam Lee, and I've been working with municipal law and public agencies for 16 years. I'm a partner at Elshire and Winder, and in addition to general municipal public law work, I focus specifically on housing, affordable housing, and land use issues. I am involved in the current SB 9 litigation. If you are aware that several cities in Southern California have sued the state with respect to SB 9, and we are just getting started on that. And with respect to this RENA lawsuit, I was involved and am currently involved in the Orange County Council of Governments lawsuit against HCD for their RENA determination for the Southern California region, or SCAG. And so I'll be talking a little bit more about all of that through this presentation, but as part of that, I have a PowerPoint that I would like to share with everyone. And to the extent that you have questions, feel free to raise your hand or interject, but I wanted to kind of get this going, and hopefully I can share my screen and it will work. Okay, so.
Excuse me, Pam, I'm going to interrupt for just a moment because
sure.
If you have questions, go ahead and put them in the chat. We're going to take questions at the end. We're going to let Pam have her get through her presentation before we do questions. So go ahead. If you feel like you might forget your question and want to put it out there, go ahead and put it in chat, and you'll have an opportunity to either ask it live at the end, or we'll ask it on your behalf out of chat. So thank you, Pam. Go ahead.
Perfect. Thank you, Julie. Thank you, Susan. So what I would like to go through as part of this presentation is give you a brief outline of what the state audit actually said and what its findings were, because I think it's important to understand what the scope of the audit was and how we could use that scope, because it wasn't a comprehensive 2-year, exhaustive forensic audit on every single regional determination. And so based on that, however, there are things that we can do in using that audit for, a potential lawsuit against HCD. So I will be going through that process, the audit findings, and then going through, the potential litigation against HCD and what legal arguments we can put forth with respect to what HCD did, what violations that occurred, and how we can get a court to fix it, and ultimately, what does that mean for each of our cities? And then I know that there are a lot of you out there that have been following this and several other cases, and then wondering, well, do we even have the ability to sue them because of these cases of the city of Irvine versus SCAG, the Southern California Association of Governments, and the city of Coronado and Solana Beach versus SANDAG, which is the San Diego Association of Governments. Those two cases basically said, well, there's no judicial review process. There was a legislative amendment that initially had judicial review, but it was removed. And so therefore, RENA allocations are not subject to judicial review. Well, how do those cases affect our ability to potentially sue HCD for its statutory violations? Is there even standing, or is that precluded altogether? And so I'll get into details about that, and then at the very end, how or why we should even get involved and what we can do to make a difference. So with respect to the RENA state audit findings, as we know, there's this process that HCD conducts every 8 years or so, less if you are not part of a council of governments. So between 5 to 8 years, HCD comes up with its RENA determination, or its regional housing needs assessment process, to basically outline for the next 8 years what cities and the state have to do in order for us to meet our housing needs, to house people and to populations. And they have a myriad of things. You'll see on the right side, a myriad of factors that they have to go through and look at with respect to data and the analysis that goes into finding the appropriate number of the projected housing units that need to be built within the next 8 years. And so as part of that process, HCD makes the determination for each region, or for a region that doesn't have a council of government, for each county. And then they have to go through that, give the determination to the council of governments. The council of governments can actually, they're tasked with providing additional information, details, and data for their specific region so that HCD can review it and make sure that they're taking into consideration the appropriate numbers and the appropriate factors. HCD comes up with its final RENA determination for the Council of Governments after taking into consideration the council's additional data. And then once that happens, each Council of Government then comes up with a methodology, a process by which these overall RENA numbers for the region get allocated to each individual city and each individual county. And then once that happens, once the methodology is created and approved, then it goes through an administrative process to allocate each city with the appropriate number of units. And each city then has an administrative review process in which to appeal that number to that Council of Governments. And then after that, once that appeal process is exhausted, the numbers become final. And of course, your city is tasked with including the RENA allocation as part of your housing element. And that's the process that we're currently going through up and down the state, considering the fact that HCD has been fairly late in approving all of the housing elements for at least the SCAG region. So then when these numbers came out, for example, in Southern California, the HCD came out with its determination of, I believe it's 1.3 or 1.4 million units in Southern California back in 2019. And the Council of Governments there made an objection. And of course, HCD responded and finalized its numbers. And then at that process, once that was concluded, a lot of the cities really made a big deal about the methodology. And there were a lot of issues involved with coming up with a formula that was actually workable for the Southern California region. And even with the number that was allocated to the SCAG region, there was a lot of infighting within the region itself, basically trying to figure out if the cities and SCAG overall should sue HCD. And I'm giving you this background because it leads up to the lawsuit and that OCOG filed, and eventually now that that's on appeal. And I wanted to let you know that because there's this overall process of figuring out what the methodology is and reviewing that, appealing that, and then appealing the actual allocation number, that becomes important because what we are going to consider for a lawsuit against HCD, there is a big difference between HCD's process in coming up with the numbers in the first place and the Council of Governments process in allocating those numbers with cities. And that is the big distinction between suing HCD versus suing a Council of Governments, which is what those two published cases, City of Irvine and City of Coronado, have done. And so I think that understanding and that distinction is important as we go through this presentation, so that you have a good understanding and grasp of the differences that are involved. And so we took a deep dive, and thanks to Gab, who basically laid out the foundation as to how and why the numbers for Southern California, as well as various regions throughout the entire state, seems so off. And, you know, there was discussions about potential overcount, double count, the vacancy rates, all of these things that we saw as part of the process, but we didn't have access to a lot of the underlying documents. And so I think with the state audit coming out with the same findings, you know, at least with the vacancy rate and some of the understanding of where there seemed to be a disconnect between the numbers that were actually provided and what we believe to be the actual numbers of projected and existing need, that there's such a big difference. So I think it's important to know that too. And so right now I'm going to go through the state audit findings so that you have a better understanding of what they looked at, what they didn't look at, because I think that too is going to be an important factor for the potential lawsuit that we're considering. So first, HCD really failed to provide the adequate analysis to support the healthy vacancy rate assumptions. And under the statute and the government code, the required vacancy rate that is stated is a healthy 5% vacancy rate for rental housing. And that's stated in the statute itself. And so what HCD did was it applied a vacancy rate of 5%, but it wasn't just for rental housing, it was for owner occupied or for sale housing as well. But we know based on statistics, a healthy vacancy rate for rental housing is typically 5%, but a healthy owner occupied housing vacancy rate is only 1.5% on average. That makes a big difference, because if you're considering that in order to have the appropriate number of housing units within a jurisdiction, if you want your vacancy rate to be at 5% for rentals, you're going to look at the current status of what the occupancy rate is and what the vacancy rate is for your rentals and make a determination. Are we unhealthy or are we healthy? Do we need more or do we need less? If you're going to apply a 5% rental vacancy or 5% vacancy rate for owner occupied housing as well, you've increased the required number of housing units that need to be vacant. So if you're looking at a 1.5% housing vacancy rate within a city or even a region, that's typically healthy. But if you're saying, no, it can't be 1.5%, the healthy rate is 5%, you're going to need 3.5% more of housing units to justify what a quote unquote a healthy rate is. So you're going to need more housing units. So that makes a very big difference with owner occupied housing. If you're going to apply an unnaturally unhealthy vacancy rate for owner occupied housing, and that's exactly what HCD has done. And so I think it makes a big difference. If you can see, the housing need was overinflated, at least for the Southern California region, by 200,000 units just for the vacancy rate alone. You know, when you're looking at 1.3 units or 1.3 million units overall, if you've got 200,000 units more than you need, that's an extra certain percentage of housing units that need to, you know, it's more than 10% that need to be applied in your jurisdiction. Where are you going to house them? Where are you going to build these housing units? So it really is a big finding that the state audit made with respect to the vacancy rates. And Gab, I just wanted to let you know, feel free to jump in because you are the resident expert here. I've studied this enough, but I'm definitely, I don't have a PhD in this. So,
You're doing a great job, Pat.
Thanks. So secondly, what HCD also did was that they obviously made silly data and calculation errors that, you know, on the face may not have made a big difference, but because only 3 regions were actually audited, they could have made a lot more errors that made a big difference that the audit couldn't reach. And so I think that's why it's important for cities to actually go back and look at the Council of Governments determination letter from HCD to determine if they actually use the appropriate data sets, and see if they correlate or if there's an error there. At least with the Southern California region, we combed through all of the data sets, and there were a lot of issues that we saw, and ultimately that's why OCOG and several other cities in Southern California ended up suing HCD. But it took a long time to get there. But I think it's incredibly important for us to have the accurate facts and the improper data sets and the improper calculation errors that they made. They use census data from the wrong year for one region. They've made simple arithmetic errors and household population numbers. I think for one region, they used, the 5-year American Community Surveys from like 2013 to 2017 for one, and then they used 2014 to 2018 for another, and they were just inconsistently applied across the board. And to the extent you want to grab a certain set of data from a 5-year period, if you're going to use the same factors but use a different 5-year period, then you're not really getting an accurate picture of what the population is doing or what the housing needs are actually going to be. And so, small minuscule errors like that can definitely lead to much huger errors that make a difference. And so for the state audit, they only looked at Amador County, the Sacramento Area Council of Governments, and the Santa Barbara Association of Governments. There are so many others that didn't get a thorough audit. And so I think it's important for you as your cities and your planners to go back and make sure that what was actually provided is actually accurate. Again, here, HCD was inconsistent in its use of comparable regions. For 3 of the regional COGs, HCD chose to use the national average of a data set, despite the fact that the national average includes rural and urban areas. But of course, the regional COGs that we are looking at, they're one of the most dense urban areas in the US. So they're completely incomparable. Imagine having the San Francisco and greater Bay Area using the averages that include Iowa, Ohio, places in Arkansas. They just won't compute. And for HCD to use national average data of that includes those metropolitan areas is incongruous. And of course, it's going to yield inconsistent numbers. That's not to say that HCD did that across the board. In some instances, they did use large metropolitan areas. And so those numbers can be more accurate in some places and not. But the problem is, and what you should understand is that overall, they're completely inconsistent. And again, the inconsistency provides for an inaccurate picture of the number of housing units that ultimately will need to be built by your jurisdiction. And that's a real problem. Again, HCD failed to consider the jobs housing balance, and they also inconsistently addressed the housing units that were lost through wildfires and other states of emergency. The analysis on the jobs housing balance that they used was outdated. It was back from 2010, and it was a draft analysis from a working group. The recommendations that they gave to HCD was to get more information from the COGs itself, because the COGs, the Council of Governments, were actually, they're tasked with providing up-to-date information about transportation, about job centers, about housing, about all these factors that are involved in order to get a jobs housing balance, a factor that is consistent and that will be actually accurate for the next 8-year cycle. But even with that recommendation, HCD did not follow their recommendation. They did not do that with the regions that were audited. In some regions they did, but at least for all 3 that the state audited, HCD just did not get that information. The HCD basically said, well, we looked at overcrowding rates, the high cost burdens, and the adjusted vacancy rates, and we believe those addressed the jobs housing balance. but then they never analyzed or provided any documentation to the state auditor with how that statement and how those factors actually contributed to or provided a better or more accurate picture with the jobs housing balance information. So they basically said, yeah, we understand what you're saying and we get it, but we already did it, but we're not going to show you how we did it. And so clearly that's a problem. They also didn't factor in, like I said, the housing that was lost through some of the wildfires. In Santa Barbara, they didn't count the Thomas Fire housing units that were lost, which means there was an undercount in the number of housing units that were needed. But in some regions in Northern California for the Camp Fire, they certainly included those numbers that were lost. So that provided a more accurate picture for those regions. I also want to add that, HCD made assumptions with respect to super commuting and median income. Super commuting, I think, is considered commuting more than 30 minutes or maybe possibly more than an hour to or from work. Their inherent assumption is that super commuting is economically driven. We obviously want to deter, super commuting, that increases time people are in their cars, idleness, and contributions to, greenhouse gases and air pollution. So obviously we want to reduce that. But what they didn't factor in was that the median income of super commuters is actually twice the median income of those who commute 30 minutes or less. Well, why is that even important? That means that super commuting may not necessarily be economically driven. That basically means sometimes it's a choice for people to actually want to super commute, that they're not forced out of a metropolitan area simply because there's just a lack of overall housing. Sometimes they choose to do that for various reasons, and HCD doesn't take into consideration that factor, which it should. Lastly, the DOF calculated the population projections. They said they did that fairly accurately, but the DOF should show the assumptions that it made in its determination of household need. Now, I think Gab could speak more on this, but I think the state legislature and the HCD assumed that DOF underestimated the number of households needed, despite their use of like 20-year trends and adjustments to cope with the differences in the markets. And HCD made its own unsubstantiated adjustments to the number of households needed. And ultimately there was like some overlap between what the DOF was doing and what HCD was doing. And it ultimately resulted in an overestimate of over 700,000 units for 4 of the largest COGs, for ABAG, SCAG, SANDAG, and Sacramento area COG. 700,000 units is a huge number. And I think the fact that that wasn't included in the audit itself shows that it obviously was not a comprehensive audit. And I think there are some other issues that are involved that the state auditor maybe could not look at or did not have time to look at in actually looking through how the DOF makes its projections. And of course, the state audit said, well, you need to show how you came up with this analysis in the first place, and you didn't. And so I think there are some real issues with that, which is why I think some of the cities in Southern California decided to sue the state, even without this audit, because we didn't know this was in the works. But had that been done, we certainly would have used more of the results. And I actually think the state auditor did not include the SCAG region because it knew that there was a lawsuit pending. So it really focused only on Santa Barbara, Sacramento, and Amador County. So, if HCD were forced to do a reassessment of its RHNA determinations, it wouldn't guarantee that all the determinations in each region would decrease. We know that there was undercount in certain regions based on certain factors. And a lawsuit isn't to specifically force them to lower their numbers. A court can't do that. A court can only say, well, you need to redo your numbers based on what the statute requires and what is allowed and what is reasonable. So you need to redo them. And so it's not a guarantee that it's going to result in an automatic lowering of the RENA determinations and the RENA allocations for each region. But it does show that overall, generally speaking, with the vacancy rate issue, the DOF population projections, and some of these other factors that were miscalculated, that we do believe there is going to be a decrease in the numbers overall throughout the state. It clearly cannot be sustained and with the facts and the evidence to justify the 2.3 million units that have been determined for the entire state. And what's interesting is, as Susan kind of touched upon it earlier, HCD did respond to the audit. It basically said, yes, we understand your concern, and we are instituting a multiple review process, and we are going to we're going to start providing that multi-review process as early as June 2022. And we're going to provide you documentation by September of 2022 to show how we came up with all the factors that were identified under Government Code section 65584. And, they said that they disagreed with the 5% vacancy rate being wrong. They thought that it was proper, but it did say it would analyze trends and it would compile updated research by February 2023. And of course, we'll see if they do that or not. They're coming up on their deadline. So, I'm not sure, not holding my breath for it, but, they may come up with something and justify their data sets and ultimately their calculations. So with respect to the potential litigation against HCD, as I've said before, the vacancy rates that are required under Government Code are specifically with respect to the rental housing market. It's supposed to be considered no less than 5%. But again, the statute says 5% for rental housing market. It is silent with respect to owner-occupied and for sale housing. But if they do want an accurate picture, it's definitely going to be a vacancy rate that's less than 5%, because I believe, the experts agree that a 5% vacancy rate for owner occupied is way too high. So I believe that, they will have a hard time justifying that vacancy rate, and legal argument for not allowing HCD to continue to use that is under this Government Code section, because it only restricts it to rental housing rates. So to the extent that they're going to use a number for owner occupied, it does not have to be 5%. And the evidence is clear that it's a much lower percentage than that. Secondly, HCD is required to use Council of Governments population forecast in reaching its RENA determination. And to the extent that that forecast varies from the DOF projection by less than 1.5%, they are required to use that COGS population forecast. That's exactly what happened in the Southern California region. I believe that COG came up with a population forecast that varied from the DOF by 1.32%. And under the statute, Government Code section 65584.01A, HCD is required to use the COGS population forecast instead of DOF or going by a different number. They did not do that. HCD just said, thank you for your information. We're going to go with a different population forecast. Under that statute, it says shall. It does not say may. And so to the extent that we've got differences in population forecasts and it varies less than 1.5%, we believe that HCD is violating the statute when it chooses to use a different population forecast number. You know, thirdly, the use of the comparable regions. HCD, again, didn't use the comparable regions when it evaluated household overcrowding and cost burden rates. They used national averages, clearly, which is inconsistent with the statutory language of SB 828, empirical data, and HCD's own internal practice. You know, to the extent that HCD does have latitude to make a determination as to what the RENA determination is, there are specific requirements in the statute that HCD is required to follow. So to the extent they go above and beyond that, we do believe that they are using their discretion in that sense, and they need to be corrected in order to follow what that statute is. Because otherwise, what's the point of having those statutes there in the first place? What is the point of having mandatory language of shall versus may? So I do believe that, you know, when you get into the details, it does become very important as to what HCD is allowed to do. And to the extent that there are other statutory violations we aren't aware of for each region, you know, that's why, you know, a deep dive into the numbers and the data is incredibly important. With respect to at least the Orange County Council of Governments lawsuit against HCD, we made a lot of these arguments, but of course, the trial court basically said that, you know, they are not allowed to judicially review HCD's determination based on, at the time, the city of Irvine case. The city of Coronado case hadn't come out yet. But because of that, they weren't allowed to review it, so they dismissed the case. And so now we are on appeal, and we are currently going through a briefing schedule. A hearing date has not been set yet. But I do want to make the distinction that, you know, when we considered whether or not we were going to sue HCD, this Irvine case definitely came up because we knew that it was there. And for the, you know, for those of you who may be unfamiliar with the city of Irvine, the city of Coronado cases, basically those two cases say that there was this legislative amendment back in 2003 that basically removed judicial review from the RENA allocation process. Now, for a little bit of history, you know, prior to 2003, as part of the statute, there is a provision, and I believe at the time it's changed, but at the time it was, I believe, Government Code section 65584, subparagraph C, that included a judicial review process for the RENA allocations. And that's where it becomes important for you to understand the RENA allocation process is where we have the Council of Governments. When they receive the RENA determination from HCD, they're supposed to come up with a methodology, and then they divvy up, in essence, the housing units that are going to be divided among all the different cities throughout that region. And of course, as part of that process, the cities can comment on the methodology process, what's going to be considered and how it's going to be divvied up. Once that public comment process is over, then they can even appeal their individual RENA allocation to that, to the COG. And so once that appeal is exhausted, what we had back in 2003 was once that appeal process was exhausted, cities can then file a lawsuit for an administrative writ of mandamus under Civil Procedure Code 1094.5 in order for the courts to review whether or not the Council of Governments allocated the numbers properly and whether or not it considered, you know, the various factors that it's supposed to consider. But back in 2003, they removed that judicial review process. They basically strike that from the statute. And so now what we have today after various iterations is we have the statute without that judicial review process. And the city of Irvine case basically said that because that judicial review process clause was removed from the statute, it basically removed judicial review from the RENA allocation process. And again, the City of Coronado case affirmed the City of Irvine case decision, but on slightly different grounds. I think Coronado and Solana Beach had filed a lawsuit based on a procedural issue, not specifically the actual allocation. And I believe the council members from the cities are here, so I don't know if they want to expand on that or not, but just as a background, that's what those cases say. But why is it important? Well, there's a lot of attorneys out there that think, well, because those two cases basically said judicial review was removed, we're not allowed to sue HCD anymore. And that was done in 2004 when the amendment became effective. So since then, they basically have immunity for their RENA determination. But I'd like to remind you that when the City of Irvine and City of Coronado sued, it was a lawsuit against the Council of Governments for the RENA allocation process, whether it was the methodology, whether it was the procedure, whether it was the administrative appeal process itself. The difference here is clearly we're not going to sue a COG. We're going to sue potentially HCD itself for that determination. And there are various differences as a result of that because they're two different processes. In the City of Irvine case, I've said before, the removal of judicial review was only specific to that subsection C, which is the RENA allocation process. If judicial review were to be applicable for RENA allocations as well as HCD's RENA determination for the region, then the statutory construct of judicial review wouldn't have been under a subsection C. It would have been its own subsection, like subsection F or J. But it wasn't written that way. It was written as a subset of the RENA allocation process. And that's where the judicial review clause was removed. Secondly, I think that the City of Irvine and City of Coronado cases really looked at the statute itself. And they said, well, in addition to the judicial review clause being removed, there's a very detailed administrative review process and an appeal process that can be done under the RENA allocation. To the extent you don't agree with the methodology, you can comment, you can object. The public can, provide its input with the methodology. In addition, the public, the city, and any interested party can comment on and even appeal. The city itself can appeal the RENA allocation that's provided to each individual city. And there's an entire hearing process that is involved with public noticing, with a schedule, and to the extent that there's an appeal board to consider the RENA allocation determination for each city, it's completely exhaustive. And there's definitely due process involved. And to the extent any interested party can make their concern known, they can do that. Is that the case with HCD's determination process? No, there is no public comment review period. There is no way for an interested party to comment. The only comment that HCD receives is the comment or series of comments from the Council of Governments itself when they're creating their RENA determination. The HCD will send out its draft determination letter to the COG, and the COG can respond, agree or disagree, or ask for modifications. And then HCD takes into consideration that comment, and then it makes its final determination. There's no real public review process. There's no appeal board. There's no public hearing process. That is all absent at the first level of HCD's determination. And so that distinguishing factor is in addition to this judicial review. And so on an equitable basis, if you're allowed to appeal your RENA allocation, the court can basically say, and the legislature can say, well, we're removing that judicial review process because we believe there's an underlying due process right that is still being used, and an opportunity for those cities to make their cases known. That doesn't exist at HCD's level for the RENA determination. And I think lastly, one important distinguishing factor is if you've got a RENA allocation that needs to be changed, then to the extent that your city's numbers are lowered, it necessarily increases the number of housing units that every other jurisdiction in your region is going to have. You know, for the Southern California region, I believe out of 52 appeals that were made for the RENA allocation, only 2, I think, were approved. And that was basically on the on SCAG's own recommendation because they miscalculated some of the numbers. And so it just necessarily shifted it around. But to the extent that an appeal process requires a reconsideration of numbers of housing units that are actually being reduced in one city, again, it is going to increase everywhere else. If you've got 1,000 units that you need to allocate and you've got 100 units to each city, and if a city gets approved as part of their appeal to only build 50 instead of 100, you're going to need to shift around 50 other units to the other jurisdictions. That's not the case with HCD. If HCD makes a different determination, it's not going to affect any other region. If HCD decides to lower the number for Southern California, that number will just be lowered, and it doesn't necessarily mean that the Bay Area is going to get another, 500,000 units, and it doesn't mean that, Santa Barbara is going to get, another 100,000 units. That simply isn't the case. If it's lowered, then it's just lowered. To the extent that then you're questioning, well, our housing elements are already addressing the 5,000 units that we need to build. And so what happens with HCD having to redetermine the overall number, and we're no longer tasked with 5,000? Well, then your housing element has provided a ceiling to the number of units that you're going to potentially have to plan for in the next 8-year cycle. If it gets lowered to 4,000, you don't necessarily have to redo or amend your housing element because they're already built, or it's already planned for the maximum number of the housing units that you're going to plan for. If there's a lower reduction in the housing units, that's simply a lower reduction. And lastly, to the extent that a court would say that judicial review is removed from HCD as part of this RENA determination, then they're basically saying HCD has complete sovereign immunity over any of the housing statutes and the housing element statutes. Then that means they can't be sued at all. Well, then if you think that that's a result that was meant by the removal of the judicial review clause, then to the extent HCD doesn't want to consider the 10 factors that they're required to consider, who can challenge that? They're not following their statute. They're not considering the 10 factors. Let's say they don't consider any of the factors. Does that mean there's no judicial review process? Because if you're reading that City of Irvine case to apply for HCD's determination overall, then that's basically what you're saying, which I believe sounds absurd. So I don't necessarily think that HCD is completely judicially immune from this process. I do think there has to be some ability for HCD or any state agency to be held accountable to following its own statute and following its own law. So like I said, there's no other due process provided for this determination. And I understand it's not completely, there's somewhat of a legislative deference for HCD in making this determination. But again, even with legislative deference, there still has to be some sort of checks and balance and review process that's allowed. And if judicial review isn't allowed, then there's absolutely no other remedy that is going to be applicable. So why should you get involved? Should you, as a city, even fight this fight, and clearly that's, a policy decision. And to the extent that, we can all live with the housing elements that we're going through and the numbers that have been provided, that's fine. But I think there does need to be a way for HCD to be held accountable. And that's not just for this housing cycle. Imagine, let's say nothing happens and the next housing cycle, they make the same mistakes. So not only are we going to repeat the problems of this one, they're going to be compounded because they're going to exacerbate the numbers that they're already using for the next cycle. And that's going to, result in a lot of, numbers that are skewed more so than even this cycle. And of course, I think it's important to really have an accurate understanding of what the housing needs really are in the next 8 years. I think to the extent that, we can get HCD to really review their own work, that's incredibly important, whether it's through a lawsuit or some other means. And it doesn't seem like some other means are, available. It looks like the lawsuit may be the only way for HCD to really have a review of their process and to get an accurate housing count. And of course, I think one big factor that is important is if a city is determined to have insufficient progress towards their RENA allocation, towards achieving the goal of creating, 100 units, 1,000 units, or 5,000 units, that opens up your city to ministerial approval of certain housing projects under SB 35. So to the extent that you should have a more accurate number, I think it's all the more important, because if you have clearly exaggerated housing units that you have to plan for, and you're nowhere near that number by the time, the midway through the sixth cycle, you're going to be subject to SB 35 approvals. And that may become a real problem if, it's 50% affordability, 10% affordability. None of that is going to be allowed through your discretionary approval process, and it's all going to have to be ministerially approved. And I think, this may be a prime example of how problematic that can be. One of the clients I work for, they're going to have an SB 35 project approval that clearly is going to provide for over 2,000 units, and there's no discretionary review process. And of course, there are environmental problems that took years to remedy. They're still going through that environmental review process, but none of that would have been allowed because CEQA is not permitted for SB 35 review projects. So phase 1, phase 2, none of that was clearly provided. And, we're dealing with, a substantial amount of housing units that kind of flew under the radar, and it got a lot of residents very, very angry. And, the city council is kind of faced with this problem that it has to address. And so to the extent that your housing element contains an inaccurate housing needs assessment, that may be a problem in the next 8 years, whether or not you're able to, to meet those RENA numbers or not. And so obviously that's definitely something to consider. And then lastly, of course, the opportunity for grants and housing may be adversely affected. So I think that's the end of my presentation, and I'm certainly happy to answer questions. So let me know what your thoughts are.